Receiving a visa refusal letter for Spain can be one of the most frustrating moments in the whole immigration process. But there is something very important you should know. A visa denial does not always mean the process is over. There are still legal options to appeal the decision or apply again correctly. My name is Blanca, an immigration lawyer at Balcells Group, and this is a situation we often see with people who applied for a visa to Spain and received a negative decision. If your visa was rejected, or if you want to know what to do in this situation, this video will help you understand the next steps. First step, understand why the visa was denied. When a consulate denies a visa, it usually sends a refusal letter or resolution. This document is very important because it explains why the application was rejected. Some of the most common reasons are incomplete documentation, doubts about your financial means, not clearly explaining the reasons for your trip, inconsistencies in the documents submitted, doubts about whether you will return to your home country. That is why the first step is always to carefully analyze the reasons for the refusal. Without this analysis, any appeal or new application may repeat the same mistakes. What options do you have after a visa denial? Many people think that when a visa is rejected, there is nothing else they can do. But that's not true. After a visa denial, there are usually three possible options. 1. File an administrative appeal at the consulate. 2. File a judicial appeal before Spanish courts. 3. Submit a new visa application correcting the previous mistakes. The best option always depends on the reason for the refusal and the documents available. Administrative appeal. One of the first options is to file an administrative appeal. This appeal is submitted to the same consulate that denied the visa. The deadline is usually 1 month from the date you receive the refusal notice. In this appeal, you must explain why the decision is not correct, respond to the reasons for the denial, provide additional documents that support your case. The goal is to prove that you actually meet the visa requirements. Judicial appeal. Another option is to file a judicial appeal. This appeal is not submitted to the consulate but to Spanish courts. Normally, the deadline is 2 months from the notification of the visa refusal. Unlike the administrative appeal, it is a court procedure. It requires a lawyer and a legal representative. It usually takes longer and can last years. However, it can be better chances of success, especially when the consulate misinterpreted the documents or made a mistake when evaluating the application. Applying for the visa again. In some cases, the best strategy is not to appeal but to submit a new application visa. This may be recommended when important documents were missing, the original application was weak, your personal situation has changed. For example, you now have more financial resources, you can provide additional documents, or you can better explain the purpose of your trip. In this situation, submitting a stronger application may be the best option. Common mistakes after a visa denial. One of the most common mistakes is submitting exactly the same application again. That is why it is essential to analyze the refusal letter, identify the weak points in the application, prepare a proper strategy before applying again. Receiving a visa refusal can be frustrating, but it does not always mean the end of the process. In many cases, there are still legal options to appeal the decision or apply again correctly. At Balcells Group, we can analyze your refusal letter and your case to design the best legal strategy for your situation. If you would like a personalized evaluation, you can contact us at info@balcellsgroup.com. Subscribe for more practical content about visa, residence permit, and Spanish nationality. See you in the next video.